Good morning. Clerk Mellon, would you please lead the commission for Justice Botsford?
To all to whom these present shall come greeting. Noting that read by our governor. Michael Botsford, the next claim, do hereby under the laws of the Commonwealth of Massachusetts, as most recently amended, constitute and appoint Michael Botsford to be Associate Justice of the Supreme Judicial Court, effective as of September 4, 2007. When you do authorize and enjoin the perform all the duties on the Senate committee, Michael Botsford is invested so long as the Senate committee to hold the same diverse at Boston, the 6th day of September, 2007, and of the independence of the United States of America, the 232nd.
Justice Botsford, welcome to the Supreme Judicial Court.
Thank you.
Clerk Mellon, would you call the first case, please?
City of Cambridge versus Department of Telecommunications.
Mr. Kawai, good morning. You may proceed.
Thank you, Your Honor, and good morning to you, too. In 1997, the Massachusetts State Legislature deregulated the electric industry to allow consumers of electricity to purchase energy from the competitive market. And in so enacting this legislation, they also permitted municipalities, as consumers of energy, to purchase streetlights and equipment from their local public utility. And the purpose of allowing these consumers of electricity to buy energy from the competitive market was because the utilities were charging extraordinarily high rates.
I have one basic fact question. The Attorney General, in her brief on page 30, says that the fact that the city purchased all of the municipal street lighting equipment owned by the company. But the DTE's opinion says the opposite. I believe that you didn't buy all of the equipment.
I believe we did buy all the equipment.
What, all the equipment?
All the streetlights and equipment within the city of Cambridge.
All right, okay, that's what
But not those streetlights on private property, for example. Not those streetlights that are that you.
Oh, if they're private streetlights,
yeah,
right? Then we didn't buy them. But all of NSTAR's equipment and streetlights within the city of Cambridge.
Okay.
Purchased.
And that includes existing equipment that is no longer in use?
Well, if yes.
Does it include equipment that has been removed?
No.
So it's only existing. It's all existing equipment, whether or not it is currently in use.
Right. They did buy all the existing street lighting equipment. They did not request that any of the street lighting equipment be removed in the sale. They did not.
Go ahead. And that includes what? What is the lighting equipment? The wiring, the poles, the lamps?
The poles, the bulbs, the glass over the bulbs, the underground, the circuits, the
service equipment, trucks.
Right.
Trucks, vehicles, no.
Just the street lights and conduit and wires, just to allow the city to be able to purchase energy from the competitive market.
Okay.
Mr. Kawai, this may be a very ill-informed question. Does the city, I don't believe it's in the record, and if it isn't, you can tell me, it may not be in the record. Does the city begin its own amortization of the equipment that it's purchased, even if it is existing equipment?
I am not sure about that. You mean presently, does it amortize the equipment?
Yes.
I'm not sure about that. I can.
It would have to.
I would think it would have to, but I haven't checked with our finance and Department of Public Works to see if they actually do that presently.
Okay.
I'm confused about something. It seems to me that the arguments of the parties don't dovetail exactly. You're representing the city, and the city talks about removing retired equipment that happened years before the acquisition. Is that right?
Right.
Okay. The Attorney General and the DTE seem to me, I may be wrong, but seem to think that that property is compensable in some way. And why, if it's no longer in use, should the city have liability for it? And why should the company be earning any return on an investment in it? That's what I don't understand. Apparently, I guess, under the uniform system of accounts, that's the way it's done.
Right.
Am I right?
Right.
But that doesn't make sense.
Right. That's exactly our point. Maybe
That
if
is
this-
okay.
If this was a rate-making proceeding or a proceeding where...
Right, but this isn't a rate-making proceeding. It's not a section 34, not 94.
Right.
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 Okay. So, and your argument is that they're applying rate-making techniques to this statute, and they shouldn't.
Right.
Okay,
Or
I got it.
other sort of proceedings where the company is trying to determine a reasonable return or profit.
Since this is property that's not making any, it shouldn't be earning any rate of return, why should you be paying for it?
Right. This is a purchase of equipment. It's purchase of depreciated equipment, and that's all it is.
But your argument is you have to pay the unamortized investment,
Right.
which you would agree is the book value of the gross plant and service minus accumulated depreciation. And your argument is, what is accumulated depreciation? Right?
Yes.
What does it include? And where do we look for that? Why isn't DTE's analysis of what is standardly viewed as accumulated depreciation a reasonable analysis?
Well, it is reasonable. The depreciation rates quoted by the DTE are, and I guess the company are reasonable. It's around 6% per year. We're not disputing that. We're disputing the cost of removal of past equipment.
But they say that's included as one of the elements of accumulated depreciation. Maybe I'm wrong about that, but I thought they were saying it's depreciation taken in prior years, less original cost of equipment retired in those prior years, plus the net salvage, which is the cost of removal minus whatever values are realized from the disposed property. That's accumulated depreciation in their view, as I understand their brief.
Well, in our view, the depreciation is the gradual aging and decreasing of value of the equipment. I believe their argument is that costs of removal, they take the legislature in Section 34A, Chapter 164, Section 34A, says that the city is required to compensate the company for the depreciated value of equipment, net or less any salvage value obtained under the circumstances.
I thought it was the unamortized investment.
Right. Unamortized investment, I think it's undisputed, means depreciated value of the equipment. And their net of any salvage value with regard to the transaction. And they're saying the salvage value is negative.
Well, there's no salvage value here. I mean, we have to distinguish the two. When we're talking about net salvage in the context of accumulated depreciation, we're talking about it as a component of accumulated depreciation over time. Net salvage, certainly, there may be a transaction where you buy some or you buy some and ask that some be taken down, where there may be a net salvage component in the transaction, in other words, in the circumstances of the purchase. But you agree there's no net salvage here.
Well, and I agree. There is. I don't believe there was any net salvage here, but the legislature did provide that the price of the depreciated equipment should be decreased by the net salvage value of any. If they were to transfer all the lighting and wiring and the equipment, certainly some of it might be left over, or they might take some of it, and they would have to decrease the price the city would pay by the salvage value of the equipment that they're taking.
And that's not at issue here.
That's not an issue.
All we're talking about is accumulated depreciation and what that means for these purposes.
Well, they're arguing that there is a salvage value added to the price. They're saying it's not a salvage value subtracted from the total purchase price. They're saying it's added because the cost of removal results in a negative net salvage value.
Now, you didn't ask them to remove anything.
No, we didn't.
Okay.
Right.
Was there any expert testimony on this?
Yes, there was in the proceeding below before the DTE.
And did the DTE accept the expert testimony of the company and
Yes.
others?
They
Well, then
did.
what's wrong with that?
Because The DTE is given discretion to accept, you're right, testimony from
And just
their
like a
experts.
jury might accept one expert and discount another expert.
Right, but the method of the calculation is not in accordance with law. The agency is not given full discretion to accept the calculation.
Well, what did they include in the calculation or exclude that you say is wrong?
The cost of removal of prior equipment.
So this whole case comes down to that, in your opinion?
Right. I think that
I understand your, but according to the DTE, FERC, and accepted methods of accounting, do it that way. According to the DTE, include cost of removal. And I assume there was expert testimony that that is proper.
well,
that right?
that's possible in a rate-making case. The city didn't take a position on that. But this is a sale of equipment.
I take it in any event, you're looking at the statutory language and the purpose of the statute.
Right. Section 34A is the statute that governs the deregulation of the electric industry.
Mr.
there-
Kawhi, excuse me, Justice Arnold, go ahead.
Is there any legislative history that sheds light on what they meant when they talked about the sale of equipment?
No, I searched the legislative history, and there wasn't direct, I don't believe, testimony regarding that. But the legislature's testimony that I did see indicated that they wanted to encourage municipalities to purchase this equipment so that municipalities could save money by purchasing electricity from the competitive market due to the high rates that the public utilities were charging.
At the expert testimony before the DTE, was the expert testimony that the FERC accounting methods and the other standard accounting methods, were those used for rate making?
They were correlating them with the rate-making proceedings, the FERC and including costs of removal and net negative salvage value.
Is there any expert testimony that including costs of removal in accumulated depreciation is proper for determining sales prices?
No, there wasn't, because this deregulation was fairly new, and there was no prior case law regarding this.
Mr. Kawhi, to ask Justice Cowen's question in a slightly different way, if we look at the record, did Cambridge challenge the expert testimony on the basis that whatever the normal general accounting accepted standards in a rate-making situation were improper for these purposes, because presumably underlying any rate-making proceeding is the assumption that in due course and over time, equipment will have to be removed, correct?
Right.
I take it that Cambridge, in due course and in time, will have to remove some of that equipment that it has purchased, correct?
Yes.
And I take it that reduced to its essence, and correct me if I'm wrong, that Cambridge is saying we're going to have to pay for the cost of removal in due course and over time, and we're having to reimburse the seller for equipment that has not been removed and we have not asked to be removed.
Right.
Is that correct? Is that the essence of the argument?
Yes.
But isn't that wrong?
that-
I mean, excuse me, go ahead.
Well, there's two sets of equipment here. I think the Chief Justice was just talking about the equipment that's currently in place, correct? Is that right?
I'm sorry,
So
I may
that-
have misunderstood. Could you
Well,
restate?
it was premised on my first question asking whether all of the equipment that my very first question, whether all of the equipment we were talking about is currently in place.
Right.
So you will have to replace that. But what the issue in this case is whether the statute requires you to pay for past, I take it, unrecovered costs of removal that could have been 20, 30 years ago. Is that right?
Right.
And the question that I had about that is, why wasn't, if you know, and maybe Ms. Martin could answer this, but why wasn't that cost or those costs of prior removals, why weren't they included in previous rate-making proceedings as depreciable costs that should have been recovered?
They very well might have.
They might have been recovered, you think?
Yes.
we're not sure
in
about
part.
that.
In part, correct?
Right.
And
And
in fact, any remaining, if in fact you're correct, the remaining pool of these accumulated costs will be charged to the ratepayers.
if they want to have a renewal of the rate-making proceeding and wish to recover those costs from them, yes, they can. They most likely will be able to recover those costs, or it could come out of their reasonable return that they make. But this is not a proceeding about that. This is a proceeding for a municipality to exercise its rights to.
Well, you bought a system. You bought a system of lighting, the whole system in the city of Cambridge. You purchased.
Right.
And so there's an unamortized value to that system. And the question is how you calculate that when you buy an entire system. And maybe you do buy accumulated, undepreciated costs, which is cost of removal minus surplus, that have accumulated over time. Why isn't that part of the unamortized value of the system?
I think that's inconsistent with the statute. And I think that
The statute's in the context of energy regulation. So the notion that FERC and other institutions use accounting principles of this sort to value systems is not irrelevant to this.
right, the statute is the controlling statute, but I do think that the accounting systems are not irrelevant, but I think including costs of removal directly contradicts the statute.
Is that because of the words in the sale under the circumstances?
Under the circumstances and including costs of removal in the second part where the city explicitly requests that they be removed. And also, it just doesn't comport with common sense with regard to a sale. If I think in my brief where I stated that if the company in 2002 were to have removed all the lights save for one, and in the next year were to purchase that light, the cost of removal will make that one light astronomical. And I think those costs, if that's an extreme example, but those
I doubt
costs
you
would
would
be,
I doubt you would purchase the system if it was one light.
yeah, and that would be right, and that would be against public policy because the legislature wanted to encourage municipalities to buy energy from the competitive market. So,
Thank you, Mr. Kawai.
thank you.
Ms. Martin?
Good morning, Your Honors. Mary Ann Reynolds Martin, representing the Department of Telecommunications and Energy, now known as the Department of Public Utilities. I'll be splitting my time with Attorney Keegan, representing the intervener company. As a threshold matter, this court lacks jurisdiction over the appeal and should dismiss it because the appeal was taken untimely.
Why? You didn't allow any time for mail. Mail doesn't get there. Mail doesn't arrive the minute you put it in the mail.
The statute, Chapter 25, Section 5, requires the Commission to serve by mail and provides that the date of service is the date at which the 20-day clock starts to run. Therefore,
But what about
we don't
the
add
rule of
for
appellate
mail.
procedure that says that when something is served by mail, whenever it's serviced by mail, 3 days are added to the prescribed period?
I believe you're referring to the rule of appellate procedure, 15C.
Yes.
I would submit that that does not apply in this situation for at least two reasons. One of which is Appellate Rule 1 prohibits the rules to be interpreted in such a way as to expand the court's jurisdiction. And if you were to apply 15C here, it would expand the court's jurisdiction by adding at least 3 days to the period of time in which an appeal could be filed. Second, 15C itself applies when after service of a paper, and I would submit that the department's decision is not service of a paper, and therefore that text would not apply on its face.
Ms. Martin, I don't wish to minimize the strength of your argument, but it would be very helpful if you turn to the substance.
Very well. In terms of the merits, if you reach them, you should affirm the department's decision because it's consistent with the statute, it's consistent with department regulations, and it's consistent with the accounting standards followed nationally under regulation by the Federal Energy Regulatory Commission.
Yes,
Could you
but are
explain
those
that?
accounting standards for purposes of a sale or for purposes of rate proceedings?
Therefore, they're applicable here because they're for purposes of determining what unamortized investment is, unamortized investment of a regulated electric company. And under the...
If you are correct, could you explain what the second paragraph is? If the city requests a sale,
Yes.
requests removal, I'm so sorry.
Certainly. To understand the statute, I think it's critical to basically freeze frame unamortized investment once the notice of conversion is received. So unamortized investment prior to the notice of conversion chugs along under the FERC regulations. It's the regulated side. It's streetlight utility service being provided under a tariff. We know what unamortized investment is prior to the date of notice of conversion. It's very well understood. It's the FERC, and it's what we will suggest continues to apply after the date of notice.
Is the problem in this case that you cannot look at the sale as as you say, a freeze frame, as a freestanding event? It has to be viewed in the context of a rate-setting procedure that is going to go on in the future.
No, it's not that it's what happens in the future in terms of rate setting or anything like that. It's basically unamortized investment is what the legislature requires the DTE to allow the city to be the company to be compensated for. Okay. Then the question is once that notice of conversion comes in, what happens? Two things happen. One, the city gets a chance to buy the streetlights at the unamortized investment amount. Second, the city also has the right to purchase any or all of the system, and in the event that they decide to purchase only part of the system, it was clarified earlier that they did buy the whole system, but under the statute, the possibility exists
Certainly.
that a municipality would buy only part. If they buy only part, then the legislature says, well, city, in addition to the right to acquire what you did, you also have the right to ask the company to remove those unacquired parts of the system. And if you ask them to remove the unacquired parts, then you need to pay for the cost of removal. And you pay basically immediately. You pay your purchase price, unamortized value for the acquired part, and you also pay for the cost of removal. Those costs of removal are not going to be recovered by the company from ratepayers. They're not going to be recovered from the company by the company from the city over time. That's part of the price if you ask.
So that's really inapplicable here because they bought the
Absolutely.
whole system.
Yes. So we would say that under the circumstances of this particular case, the only thing that's relevant is what the unamortized investment is.
Is there anything in the legislative history that suggests what the legislature meant by, put it differently, is there anything that indicates that the legislature meant anything other than what unamortized investment typically means in a rate-setting situation?
No, I would suggest that there's not. That when the legislature used the phrase unamortized investment, that it was using a phrase that's acquired a technical understanding over years of regulatory practice, and that there's nothing in the legislative history to suggest that they were somehow redefining that term.
What about when they use in the circumstances of the sale, under the circumstances of the sale?
Okay, under the circumstances of the sale, it means that that in the circumstance of a sale, of a notice to convert, that being the sale, then the unamortized investment is going to be the compensation due. And if if the city exercises its additional right to not purchase certain equipment, but to ask for that equipment to be removed.
But they didn't here, so let's forget that, because that's just...
But he says removal costs were included.
Yeah.
Is he right or wrong?
These are old removal costs.
Exactly.
Why should the city pay for old removal costs? That's really the basic question, it seems, between you two.
The city should pay for old removal costs because old removal costs are a component of accumulated depreciation under standard accounting practices, under the FERC regulations, which were adopted by the department.
Does the department concede, acknowledge, agree with the claim that in this case there would be little or no savings to the city? I mean, essentially what the city's claim seems to be is we're trying to get it at a cost which will encourage cities to, if they want to purchase the equipment. And they seem to be saying we are now getting stuck with some huge cost, i.e. the purchase price that we didn't anticipate.
Well, I understand that they're trying to reduce the purchase price, but that doesn't necessarily mean that the purchase price is in any way uneconomic for
But
them.
try to pierce your argument, it's a component of accumulated depreciation under FERC standards adopted by the department. Yes, but is it a component under standards adopted by the department for rate-making purposes?
It is a unamortized investment as a phrase that was used by the legislature in the statute we submit has a technical meaning that has been interpreted and applied by the department in rate-making proceedings, and that the purchase of the streetlight system was previously the rates for use of that system while it was owned by the company was a rate established in
And presumably the city was, in accordance with the rates that the department authorized, paid for some of those expenses, costs, whatever the word is that you want to use, correct? As a user, as a consumer.
Yes. And so, and like Justice Cordy was mentioning before, it's that some of those costs have been recovered, but they're buying the system. And when they buy the system, they're buying whatever debt the company still has in the system if they have not yet fully recovered the costs.
But that sounds like it sounds like what you're doing is calculating the amortized cost, not the unamortized cost.
No, calculating the unamortized cost consistent with the way that the department interprets the statute has always interpreted unamortized
But for
investment.
rate making, and because this is a new procedure, we never had municipalities buying the equipment before and going into the business themselves.
The company is a regulated company. The city is purchasing the regulated side of previously regulated component of the company. The department's interpretation of unamortized investment is entirely reasonable. It's entitled to deference. It's consistent with their other streetlight decisions that they've made, consistent with really the understanding of the industry. And it's
Was the expert testimony before the DTE that unamortized investment included prior costs of removal when municipalities were buying streetlight equipment, or was it only that it included it for rate-making purposes?
They didn't buy it before.
Right, because they
97.
didn't. Right. So
the expert testimony is included on page 340, 341. That's one of the places. It was the company's expert that explained how they calculated what their unamortized investment was.
Yeah, of course.
And I'm not aware of specific expert testimony that in a streetlight purchase situation that somehow unamortized investment all of a sudden means something different than it's always mean.
But was the company earning any return on its investment in the removed equipment?
The company I suppose that it would have been under the rates it was collected, the tariff rates when people purchase the street lighting service off the tariff rate. I can't say specifically, but that would have been a rate established by a tariff that could have allowed for profit. But in this case, there's no profit because it's just unamortized investment. They're not multiplying that by a cost of capital.
So you're saying the term unamortized investment is a term of art that's used in this comprehensive statute, and that it includes the cost of removal of retired equipment.
Yes. Yes. And so, yes.
Okay.
I think my time is run.
Thank you, Ms. Martin. I'll ask Mr. Keegan. Mr. Keegan, good morning.
Good morning. Thank you, Your Honor. If it pleases the court, my name is Robert Keegan, appearing on behalf of Cambridge Electric Local.
And perhaps you could throw some light on some of the questions, Mr.
I will
King.
try, but there's so many questions, I'm not sure I can cover
Are
it
the
all.
lights still on in Cambridge, by the way?
They never were.
Let me start there.
It's a pretty simple point, though, isn't it? I mean, when you include this cost of removal, you're talking about unrecovered cost of removal, aren't you? That they haven't been paid, no?
No, I don't think so. Let me first start and say that we're attempting to value utility property
Yeah.
for the sale to a municipality. Utility property
But the
is-
sale to anybody, correct? It happens.
for the sale to anyone. But utility property is different from other property. It's subject to pervasive regulation.
It was.
Has been.
It was.
Well, no, the property, the distribution property and the property owned by distribution companies continues to be subject to pervasive regulation, not generation assets. That's essentially been deregulated. But pursuant to the Chapter 164, the department has establishes, through accounting treatment, everything about the utilities property. It establishes how the property will be used, what the rates of depreciation will be, whether or not you're able to, how much of a profit you can incur on it. And the distinction between rate making and other things the department does, I don't think really applies.
It doesn't apply, but you understand, I take it, Mr. Keegan, that part of what is included here is the unamortized costs of equipment that was previously removed because it was defunct, correct? I mean, it had been replaced, whatever.
That's
correct?
a part of the accounting system.
And so it seems counterintuitive. I mean,
Well-
will you at least concede that it seems counterintuitive that a purchaser, whoever the purchaser is paying for, forget the term that you would use, equipment that was defunct and removed maybe in 1972 or 1982?
If you look at it on an individual streetlight basis, perhaps. But that's not how the uniform system of accountants works.
Of course not.
It
yeah.
requires that for all investment, the company book to account 373 the original cost of the investment plus whatever it costs to install it. That's what sits on the asset side of the balance sheet. On the liability side, we have accumulated depreciation to offset that. And so over the past 60 years, following the uniform system of accounts, the company puts into accumulated depreciation the depreciation that it collects in rates related to street lighting, and that builds up a reserve for depreciation. Then, when the company removes street lights, under the accounting rules, it has to pull out of the reserve for depreciation the original cost of that street light, and then offsets that with any costs incurred to remove that street light, net of any salvage that it receives or any insurance reimbursements that it receives.
It sort of makes sense, doesn't it? I mean, if you sell me a car and a week before I bought the car, you took out the engine and replaced the engine, conceivably, you reasonably might be entitled to the cost of removal of the old engine.
I'm going to be looking for a reimbursement, but I would say there are lots of different ways of valuing that asset. Market value, replacement value, some discount to those values. That's not what the legislature said. The legislature set out very specifically unamortized value. That is a term of art, has a very specific meaning in utility regulation that is in fact controlled over the past 60 years by the uniform system.
Did these folks at the hearing or whatever occurred object to the expert that you guys presented or they presented saying this is the way you do it?
I think it was a conflicting testimony. The company had
Oh,
experts
but did they say we object to this and we want it excluded?
They proposed a different methodology for calculating it, which varied from what the company's
Well,
books of account
you
were.
see what I'm getting at? If this is like a trial and you don't make an objection to the expert, it comes in for whatever weight the fact finder wants to. So they didn't make an objection.
And that's what the department did here, and it found, based on substantial evidence in the books and records of the company, that this is what the value, the unamortized value is.
Is it true that some of these historical costs of removal minus surplus would have been, in essence, depreciated, charged against the rates? They don't just accumulate in a little account over here, never to be charged to the ratepayers, and now you want it all back.
Well, yeah, when the department's setting rates,
Right.
the value that's left on the books of the company over time may be greater or less than the market value. You really have to go back and take a look at how did the department create the rates, and
You're missing my point.
I'm
I
sorry.
think you're missing my point. You've got these accumulated costs, which are the cost of removal, because you're constantly removing equipment, all
Yes.
right? And you say that goes on the ledger.
That offsets accumulated depreciation, yes?
Right, minus surplus that you get or insurance proceeds.
Yes.
So you're accumulating some unreimbursed costs over here. At some point in the rate setting process, are those made part of the rate?
Yes.
Are those recovered through the rate?
Yes.
They made part of the rate every time there's a rate setting process.
Yes, that's correct.
But
A
the
certain portion
sale,
of
the sale,
Yes.
the sale occurred before, as it were, it's an ongoing process, and so you're cutting it off at some point because there's a sale, correct?
So are
correct.
you saying, in effect, you're earning a rate of return on this?
No, there's no.
So then, if you're not earning a rate of return on it, why are you entitled to include it here?
In the calculation of unamortized investment, there's no profit or rate of return. Now, when the department establishes rates,
Then
while
there's-
the utility owns the street lighting, it takes unamortized investment and allows a return separate and outside of unamortized investment. But here, it's not a component in unamortized investment, and in the price that's established for the city to take those lights over, there's no profit in that. It represents what the original cost of the lights were, offset by the accumulated depreciation that
But
developed.
didn't you say, though, that included in here would be some cost that might have already been recovered?
The answer to that
It's
question-
really, it's static in the background. Perhaps if you looked at an individual light that may have been retired early, but you'd have to
Mr.
go
Keegan,
back.
the answer to that question has to be yes, because that's the way the process
Yes.
works. The answer is yes.
It is
I mean,
possible.
and that's what goes to what's counterintuitive here, but the question is whether the legislature knew what it was doing when it used that term.
I believe they did, and you have to look at the entire system in the streetlights. If I could just, one other, the city relies a lot on two subsequent paragraphs in that statute. And I have to say, those provisions are entirely consistent and identical to what the uniform system of accounts is. And I say that by saying the legislature knew what it was doing here. The one that says, look, identify what unamortized investment is. That's a snapshot, a picture in time. Those two legislative provisions recognize something can happen after you've taken that picture. And one is that as a part of the sale, there's some excess bulbs or lights. If that has salvage value, in the circumstances of the sale, you have to offset the price.
You deduct it, yeah, sure.
And finally, if you look at the situation where they want the company to remove streetlights, they have to, exactly the way the uniform system of accounts would require the utility to account for. They have to remove the cost of removal and reimburse the company for the unamortized value of that streetlight, net of any salvage. It all works.
When the city of Cambridge goes to apply for a rate to be set to the people in the city that are buying or that are
Yes.
getting the advantage of the street lighting, will this unamortized investment figure be included in the calculation of its rate?
No, it's now off the
It's
books
off.
of the company.
It's off.
And the city now owns those lights, and so there is no value to that lighting equipment any longer. It's for the distribution of the electricity to get to those lights and the energy cost of the electricity.
Thank you, Mr. Keegan.
Thank you very much.